All right, let's bring the jury in. Good afternoon, everyone. Please be seated. All right, ladies and gentlemen of the jury, the evidence in the case has been presented and the attorneys have given their summations to you. We now arrive at the time when you, as jurors, ought to perform your final function in this case. I do have a rather long charge to go through, and then we'll review the verdict sheet in this case. If at any time during my charge to you, you feel the need to stand up and stretch, I will certainly understand. I won't hold it against you, and please feel free to do so. All right, I'm hoping it's an hour or so, maybe a little bit longer, depends on how fast I get through everything I have to tell you. So if you feel the need to stand up, please don't worry, I won't be offended by it. I understand. All right. At the outset, let me express my thanks and appreciation to you for your attention to this case. I would like to commend counsel, first for the professional manner in which they have presented their respective cases, and for their courtesy to the court and jury during the course of this rather long trial. Before you retire to deliberate and reach your verdict, it is my obligation to instruct you as to the principles of law applicable to this case. You shall consider my instructions in their entirety and not pick out any particular instruction and overemphasize it. Generally speaking, these instructions consist of 4 parts. The first part deals with the general principles of law that apply to a criminal case. The second part describes the evidence that you may consider in your deliberations. The third part is about the portion of the Criminal Code of New Jersey that you must apply to the facts you find in this case to determine whether the state has proven beyond a reasonable doubt that the defendant violated a specific criminal statute. Finally, the fourth part of the instructions tells you how to go about conducting your deliberations. You must accept and apply this law in this case as I give it to you in this charge. Any ideas you have of what the law is or what the law should be, or any statements by the attorneys as to what the law may be, must be disregarded by you if they are in conflict with my charge. Turning first to the nature of the indictment. The general principles of law that apply to a criminal case, the defendant stands before you on an indictment returned by the grand jury charging him with 2 counts of attempted murder and 2 counts of possession of a weapon for an unlawful purpose. The indictment is not evidence of the defendant's guilt on any of those charges. An indictment is a step in the procedure to bring the matter before the court and jury for the jury's ultimate determination as to whether the defendant is guilty or not guilty on the charges stated in it. The defendant has pleaded not guilty to the charges. The defendant on trial is presumed to be innocent, and unless each and every essential element of an offense charge is proved beyond a reasonable doubt, the defendant must be found not guilty of that charge. The burden of proving each element of a charge beyond a reasonable doubt rests upon the state, and that burden never shifts to the defendant. The defendant in a criminal case has no obligation or duty to prove his innocence or offer any proof relating to innocence. The prosecution must prove its case by more than a mere preponderance of the evidence, yet not necessarily to an absolute certainty. The state has the burden of proving a defendant guilty beyond a reasonable doubt. Some of you may have served as jurors in civil cases where you were told that it is necessary to prove only that a fact is more likely true than not true. Yes, Katie, lock that door. Nobody gets in. Nobody gets out. And if we need an officer stationed outside, officer, I'm sure you have one available for us.
We called someone to lock it.
Right.
Yeah.
Sorry about that, folks. The prosecution must prove its case by more than a mere preponderance of the evidence, yet not necessarily to an absolute certainty. The state has the burden of proving a defendant guilty beyond a reasonable doubt. Some of you may have served as jurors in civil cases where you were told that it is necessary to prove only that a fact is more likely true than not true. In criminal cases, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. A reasonable doubt is an honest and reasonable uncertainty in your minds about the guilt of the defendant after you have given full and impartial consideration to all of the evidence. A reasonable doubt may arise from the evidence itself or from a lack of evidence. It is a doubt that a reasonable person hearing the same evidence would have. Proof beyond a reasonable doubt is proof, for example, that leaves you firmly convinced of the defendant's guilt. In this world, we know very few things with absolute certainty. In criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you are not firmly convinced of the defendant's guilt, you must give the defendant the benefit of the doubt and find him not guilty. The function of the judge is separate and distinct from the function of the jury. It is my responsibility to determine all questions of law arising during the trial and to instruct the jury as to the law that applies in this case. You must accept the law as given to you by me and apply it to the facts as you find them to be. During the course of the trial, I was required to make certain rulings on the admissibility of the evidence, either in or outside of your presence. These rulings involve questions of law. The comments of the attorneys on these matters were not evidence. In ruling, I have decided questions of law, and whatever the ruling may have been in a particular instance, you should understand that it was not an expression or opinion by me on the merits of the case. Neither should my other rulings on any other aspect of the trial be taken as favoring one side or the other. Each matter was decided on its own merits. I may have sustained objections to some questions asked by counsel, which may have contained statements of certain facts. The mere fact that an attorney asks a question and inserts facts or opinions in that question in no way proves the existence of those facts. You will only consider such facts which in your judgment have been proven by the testimony of witnesses or from exhibits admitted into evidence by this court. The fact that I may have asked questions of a witness in this case must not influence you in any way in your deliberations. If I recall, I may have asked a few minor questions, clarification questions for witnesses. The fact that I ask such questions does not indicate that I hold any opinion one way or the other as to the testimony given by that witness. Any remarks made by me to counsel or by counsel to me or between counsel are not evidence and should not affect or play any part in your deliberations. As I instructed you when we started this case, I explained to you that you are the judges of the facts. And as judges of the facts, you are to determine the credibility of the various witnesses as well as the weight to be attached to their testimony. You and you alone are the sole and exclusive judges of the evidence, of the credibility of the witnesses, and the weight to be attached to the testimony of each witness. Regardless of what counsel said, or I may have said recalling the evidence in this case, it is your recollection of the evidence that should guide you as the judges of the facts. Arguments, statements, remarks, openings, and summation of counsel are not evidence and must not be treated as evidence. Although the attorneys may point out what they think important in this case, you must rely solely upon your understanding and recollection of the evidence that was admitted during the trial. Whether or not the defendant has been proven guilty beyond a reasonable doubt is for you to determine based on all the evidence presented during the trial. Any comments by counsel are not controlling. It is your sworn duty to arrive at a just conclusion after considering all the evidence which was presented during the course of the trial. Now I will move on to the second part of the instructions and discuss the evidence that you may consider in judging the facts of this case. When I use the term evidence, I mean the testimony you have heard and seen from the witness box any stipulation, and the exhibits that have been admitted into evidence. Any exhibit that has not been admitted into evidence cannot be given to you in the jury room, even though it may have been marked for identification. Only those items admitted into evidence can be given to you. And at this point, I do want to advise you of how you will receive those exhibits. And this is because of COVID protocols still in place. You will have this laptop with you in the jury room. There are 2 thumb drives with state exhibits and defense exhibits that both counsel have reviewed. So we know that those are the only exhibits in evidence that you'll be able to review. You can use the laptop and the thumb drives to review all the evidence in the case. Photographs, things of that nature, everything admitted, other than physical evidence, of course, will be on those thumb drives for you to review. When you first retire to the jury room, there will be an IT person that works for the judiciary who will be sworn and will take the laptop and those thumb drives into you and show you how to use them. Although I would guess that most of you probably know how to use a thumb drive and a computer anyway, but just for our peace of mind, he'll go in there and he can answer any questions you have about how to use the computer and view the evidence. All right? And there will be other separate physical evidence that will be moved in. Is that correct, Mr. Shellhorn?
Yes, Your Honor.
Yes. Any testimony that I may have had occasion to strike is not evidence and shall not enter into your final deliberations. It must be disregarded by you. This means that even though you may remember the testimony, you are not to use it in your discussions or deliberations. Further, if I gave a limiting instruction as to how to use certain evidence, that evidence must be considered by you for that purpose only. You cannot use it for any other purpose. As jurors, it is your duty to weigh the evidence calmly and without passion, prejudice, or sympathy. Any influence caused by these emotions has the potential to deprive both the state and the defendant of what you promised them, a fair and impartial trial by fair and impartial jurors. Also, speculation, conjecture, and other forms of guessing play no role in the performance of your duty. As I instructed you at the beginning of the case, evidence may be either direct or circumstantial. Excuse me. Direct evidence means evidence that directly proves a fact without an inference, and which in itself, if true, conclusively establishes that fact. On the other hand, circumstantial evidence means evidence that proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts established by the evidence. Whether or not inferences should be drawn is for you to decide using your own common sense, knowledge, and everyday experience. Ask yourselves, is it probable, logical, and reasonable? It is not necessary that all facts be proven by direct evidence. They may be proven by direct evidence, circumstantial evidence, or a combination of direct and circumstantial evidence. All are acceptable means of proof. In many cases, circumstantial evidence may be more certain, satisfying, and persuasive than direct evidence. However, direct and circumstantial evidence should be scrutinized and evaluated carefully. A verdict of guilty may be based on direct evidence alone, circumstantial evidence alone, or a combination of direct and circumstantial evidence, provided, of course, that it convinces you of a defendant's guilt beyond a reasonable doubt. The reverse is also true. A defendant may be found not guilty by reason of direct evidence, circumstantial evidence, or a combination of the two, or a lack of evidence if it raises in your mind a reasonable doubt as to the defendant's guilt. And recall at the beginning of the case I gave an example. I'm not going to repeat it in full here. I'm sure you remember it, of my children going to sleep at night and looking out the window to see if it was snowing before school. They testified they saw snow falling before they went to bed. That's direct evidence. If they didn't see snow on the ground, they didn't see snow falling when they went to bed, but they woke up in the morning, they saw snow covered on the ground, the snow on the ground is a fact established from which they could draw a reasonable logical inference that it had snowed during the night when they slept. All right? Moving on to the credibility of witnesses. As the judges of the facts, you are to determine the credibility of the witnesses, and in determining whether a witness is worthy of belief and therefore credible, you may take into consideration the following: the appearance and demeanor of the witness, the manner in which he or she may have testified, the witness's interest in the outcome of the trial, if any, his or her means of obtaining knowledge of the facts, the witness's power of discernment, meaning his or her judgment, their understanding, his or her ability to reason, observe, recollect, and relate, the possible bias, if any, in favor of the side for whom the witness testified, the extent to which, if at all, each witness is either corroborated or contradicted, supported or discredited by other evidence, whether the witness testified with an intent to deceive you, the reasonableness or unreasonableness of the testimony the witness has given, whether the witness made any inconsistent or contradictory statement, and any and all other matters in evidence would serve to support or discredit his or her testimony. Through this analysis, as the judges of the facts, you weigh the testimony of each witness and then determine the weight to give it. Through that process, you may accept all of it, a portion of it, or none of it. If you believe that any witness willfully and knowingly testified falsely to any material facts in this case, with intent to deceive you, you may give such weight to his or her testimony as you deem it is entitled. You may believe some of it, or you may, in your discretion, disregard all of it. There is, for your consideration in this case, oral statements allegedly made by the defendant. It is your function to determine whether or not the statements were actually made by the defendant, and if made, whether the statements or any portion of them are credible. In considering whether or not an oral statement was actually made by the defendant, and if made, whether it is credible, you should receive, weigh, and consider this evidence with caution, based on the generally recognized risk of misunderstanding by the hearer, or the ability of the hearer to recall accurately the words used by the defendant. The specific words used and the ability to remember them are important to the correct understanding of any oral communications, because the presence or absence or change of a single word may substantially change the true meaning of even the shortest sentence. You should therefore receive, weigh, and consider such evidence with caution. And addressing now the specific statements at issue, we'll call from the testimony Corporal Derek Heimer testified that at the scene of the shooting, defendant allegedly repeatedly stated, "I had a good life." Police officer Jason Hensley testified that while defendant was in an ambulance being transported from the scene, he allegedly repeatedly stated, "Is this real? I need to wake up." Also, Detective Jason Gould testified he heard defendant make statements while in the ICU unit at the hospital. Detective Gould testified the defendant allegedly stated in sum and substance, "They destroyed my life over the past 6 months. I had a good life. They took it all away," and that he was sorry. In considering whether or not these statements are credible, you should take into consideration the circumstances and facts as to how the statements were made, as well as all other evidence in this case relating to this issue. Among those circumstances, police officer Hensley testified that after taking custody of the defendant at the scene, he advised the defendant of his Miranda rights from a card he carried. Officer Hensley testified the defendant verbally acknowledged his Miranda rights but did not recall whether the defendant indicated he wished to speak to the officer. There was also testimony adduced from various witnesses regarding the defendant's physical injuries and mental status at the time the statements were purportedly made. Those witnesses include Corporal Heimer, Officer John Wurtenberg, Detective Jason Gould, Police Officer Jason Hensley, Mobile Intensive Care Paramedic Dan Vitale, EMT worker Kimberly Held, and Dr. Haney from the hospital. And those are only my recollection. Your recollection controls if there are other witnesses that address the defendant's state of mind, physical condition that may bear upon the statements he made and their credibility. You certainly consider those. You are not limited by that list of witnesses that I just read to you. If, after consideration of all these factors, you determine that the statements were not actually made or that the statements are not credible, then you must disregard the statements completely. If you find that the statements were made and that part or all of the statements are credible, you may give what weight you think appropriate to the portion of the statement you find to be truthful and credible. As you know, the defendant, Michael Barisone, elected not to testify at trial. It is his constitutional right to remain silent. You must not consider, for any purpose or in any manner in arriving at your verdict, the fact that Michael Barisone did not testify. That fact should not enter your deliberations or discussions in any manner or at any time. Michael Barisone is entitled to have the jury consider all the evidence presented at trial. He is presumed innocent whether or not he chooses to testify. Now, in the next section, I'm going to address some limiting instructions. During the testimony of certain witnesses, they may have made reference to the fact that information was obtained from the defendant while he was in custody at the Morris County Jail. The fact that the defendant was detained in this facility at some point is irrelevant and should play no part in your consideration of this case. You may not use this evidence in any way to infer the defendant is guilty of the charges simply because he was in custody. You have also heard references to Lauren Kanarek and Robert Goodwin having used drugs in the past. This testimony was admitted by the court for a limited purpose. Testimony may only be considered for the limited purpose of explaining or supporting the conclusions reached by Dr. Simmering and Dr. Hassan, or for assessing the value of the doctor's opinions that are dependent or rely on this information. You may not consider this testimony for any other purpose. You should not consider the testimony as substantive evidence relating to the guilt or innocence of the defendant, or consider it as reflecting the bad character of Lauren Kanarek or Robert Goodwin. You also heard testimony regarding the purported and unverified prior criminal history of Robert Goodwin and Lauren Kanarek, the defendant received from a private investigator, Joseph Blattler. The defense alleges this information affected the defendant's state of mind. I instruct you that this testimony may only be considered for the limited purpose of explaining or supporting the conclusions reached by Dr. Simmering and Dr. Hassan regarding the defendant's state of mind, or for assessing the value of the doctor's opinions that are dependent or rely on this information. Under our rules of evidence, a jury may consider a witness's criminal conviction in determining the credibility or believability of that witness. However, there is no evidence that Lauren Kanarek or Robert Goodwin has a criminal conviction. You must not consider the testimony related to the alleged prior criminal history as affecting the credibility of Lauren Kanarek or Robert Goodwin. Nor may you consider it as substantive evidence related to the guilt or innocence of the defendant. The only relevance of the evidence is the extent to which you find it may have affected the defendant's state of mind. Similarly, you have heard reference in testimony to Lauren Kanarek owning or possessing a firearm. Again, this testimony was admitted by the court for a limited purpose. Testimony may only be considered for the limited purpose of explaining or supporting the conclusions reached by Dr. Simmering, Dr. Hassan, and Dr. Schlesinger regarding the defendant's state of mind, or for assessing the value of the doctor's opinions that are dependent or rely on this information. You may not consider this testimony for any other purpose. You should not consider this testimony as substantive evidence related to the guilt or innocence of the defendant, or consider it as reflecting the bad character of Lauren Kanarek. Moving on to expert testimony, ladies and gentlemen. As a general rule, witnesses can testify only as to facts known by them. This rule ordinarily does not permit the opinion of a witness to be received as evidence. However, an exception to this rule exists in the case of an expert witness who may give his opinion as to any matter in which he is versed, which is material to this case. In legal terminology, an expert witness is a witness who has some special knowledge, skill, experience, or training that is not possessed by the ordinary juror, and who thus may be able to provide assistance to the jury in understanding the evidence presented and determining the facts of the case. In this case, Detective Andreas Zaharopoulos of the Morris County Prosecutor's Office, I did practice that name over the weekend, ladies and gentlemen. Happy to say I got it remotely correct, close to being correct. Detective Zaharopoulos of the Morris County Sheriff's Office, William Stitt of the Morris County Sheriff's Office, Dr. Stephen S. Simmering, M.D., Dr. Charles S. Hassan, Ph.D., and Dr. Louis B. Schlesinger, Ph.D., were called as experts. You are not bound by such experts' opinions, but you should consider each opinion and give it the weight to which you deem it is entitled, whether that be great or slight, or you may reject it. In examining each opinion, you may consider the reasons given for it, if any, and you may also consider the qualifications and credibility of the expert. It is always within the special function of the jury to determine whether the facts on which the answer or testimony of an expert is based actually exist. The value or weight of the opinion of the expert is dependent upon and is no stronger than the facts on which it is based. In other words, the probative value of the opinion will depend upon whether from all the evidence in this case you find that those facts are true. You may in fact determine from the evidence in this case that the facts that form the basis of the opinion are true, are not true, or are true in part only. And in light of such findings, you should decide what effect such determination has upon the weight to be given to the opinion of the expert. Your acceptance or rejection of the expert opinion will depend, therefore, to some extent on your findings as to the truth of the facts relied upon. The ultimate determination of whether or not the state has proven the defendant's guilt beyond a reasonable doubt is to be made only by the jury. You have heard testimony related to alleged statements made by the defendant during psychiatric and psychological examinations by the three experts, Dr. Simmering, Dr. Hassan, and Dr. Schlesinger. You should not consider these hearsay statements as substantive evidence relating to the guilt or innocence of the defendant, or for the truth of the matter asserted by the defendant in those statements. Rather, I instruct you to consider these statements only for the limited purpose of explaining or supporting the conclusions reached by Dr. Simmering, Dr. Hassan, and Dr. Schlesinger, or for assessing the value of the doctor's opinions that are dependent or rely on the defendant's statements. Evidence of good character or reputation of an accused is always competent in the trial of a criminal action and is entitled to be considered by you. Two defense witnesses, Philip Dutton and Boyd Martin, testified as character witnesses. You, the jury, should consider all of the relevant testimony, including that relating to the defendant's good character or reputation, and if, on such consideration, there exists a reasonable doubt of his guilt, even though that doubt may arise merely from his previous good repute, he is entitled to an acquittal. But if, from the entire evidence in this case, including that relating to good character, you believe the defendant guilty beyond a reasonable doubt, he should be convicted, and the evidence of good character should not alter the verdict. Now I will instruct you on the third part of the instructions, on the portions of the criminal code that you must apply to the facts you find to determine whether the state has proven beyond a reasonable doubt that the defendant violated a specific criminal statute. The statute read together with the indictment identifies the elements which the state must prove beyond a reasonable doubt to establish the guilt of the defendant on each of the counts in the indictment. In addition, you will have the opportunity to consider an offense beside those charged in the, specifically in the indictment. This is what we call a lesser included offense, crime or offense of a lesser degree that are considered to be included within the charges brought in the indictment. I will give you instructions about how to consider the lesser included offense later in my charge. There are, as you know, 4 offenses charged in the indictment. They are separate offenses by separate counts in the indictment. In your determination of whether the state has proven the defendant guilty of the crimes charged in the indictment beyond a reasonable doubt, the defendant is entitled to have each count considered separately by the evidence which is relevant and material to that particular charge based on the law as I give it to you. By turning first to attempted murder as charged in counts 1 and 2 of the indictment. The indictment charges the defendant with the crime of attempted murder in counts 1 and 2. Count 1 of the indictment reads in relevant part as follows. The grand jurors of the state of New Jersey for the county of Morris upon their oaths present that Michael Barisone on or about August 7, 2019 in the township of Washington in the county of Morris purposely did anything which, under the circumstances, as a reasonable person would believe them to be, is an act constituting a substantial step in a course of conduct planned to culminate in his commission of the crime of murder, specifically by attempting to cause the death of Lauren Kanarek, contrary to the provisions of New Jersey Statute 2C:5-1A3 and New Jersey Statute 2C:11-3A1, and against the peace of this state, the government, and dignity of the same. Count 2 of the indictment reads in pertinent part as follows. Grand jurors of the state of New Jersey for the county of Morris upon their oaths present that Michael Barisone on or about August 7, 2019 in the township of Washington in the county of Morris purposely did anything which under the circumstances as a reasonable person would believe them to be is an act constituting a substantial step in a course of conduct planned to culminate in his commission of the crime of murder, specifically by attempting to cause the death of Robert Goodwin, contrary to the provisions of NJS 2C:5-1A3, NJS 2C:11-3A1, and against the peace of this state, the government, and dignity of the same. In order for you to find a defendant guilty of an attempted murder, the state must prove beyond a reasonable doubt that it was the defendant's purpose to cause the death of the victims. More specifically, the law provides that a person is guilty of an attempt to commit the crime of murder if this person purposely did anything which under the circumstances as a reasonable person would believe them to be is an act constituting a substantial step in a course of conduct planned to culminate in his causing the death of the victims. Thus, in order to find a defendant guilty of the crime of attempted murder, the state must prove the following elements beyond a reasonable doubt. First, as to count 1, it was the defendant's purpose to cause the death of Lauren Kanarek. And as to count 2, it was the defendant's purpose to cause the death of Robert Goodwin. Second, the defendant purposely did anything which under the circumstances as a reasonable person would believe them to be is an act constituting a substantial step in a course of conduct planned to culminate in his causing the death of the victim. First, the state must prove that the defendant acted purposely. Purposely means it was the person's conscious object to cause the death of the victim. Whether the defendant's purpose was to cause the death of the victim is a question of fact for you to decide. Purpose is a condition of the mind which cannot be seen and can only be determined by inference from conduct, words, or acts. It is not necessary for the state to produce a witness or witnesses who can testify that the defendant stated, for example, that his purpose was to cause the death of the victim. It is within your power to find that proof of purpose has been furnished beyond a reasonable doubt by inference, which may arise from the nature of the acts and the surrounding circumstances. Such things as the place where the acts occurred, the weapon used, the location, number, and nature of the wounds inflicted, and all that was done or said by the defendant preceding, connected with, and immediately succeeding the events are among the circumstances to be considered. Causing the death of the victim must be within the design or contemplation of the defendant. The use of a deadly weapon, such as a firearm, in itself may permit you to draw an inference that the defendant's purpose was to take a life. A deadly weapon is any firearm or other weapon, device, instrument, material, or substance, which in the manner it is used or is intended to be used is known to be capable of producing death. In your deliberations, you may consider the weapon used and the manner and circumstances of the attack, and if you are satisfied beyond a reasonable doubt that the defendant shot Lauren Kanarek with a firearm and shot at Robert Goodwin with a firearm, you may draw an inference from the weapon used, that is the firearm, and from the manner and circumstances of the attack as to the defendant's purpose. Second, the state must also prove beyond a reasonable doubt that the defendant purposely did anything which under the circumstances as a reasonable person would believe them to be is an act constituting a substantial step in a course of conduct planned to culminate in his causing the death of the victim. However, the step taken must be one which is strongly corroborative of the defendant's criminal purpose. The defendant must be shown to have had a firmness of criminal purpose to cause the death of the victims. Preparatory steps, if any, must be substantial and not just very remote preparatory acts. In order for you to find a defendant guilty of an attempted murder, the state must prove beyond a reasonable doubt that it was the defendant's purpose to cause the death of the victims. The state, however, is not required to prove a motive. If the state has proven the essential elements of the offense beyond a reasonable doubt, the defendant must be found guilty of the offense regardless of the defendant's motive or lack of motive. If the state, however, has provided a motive, you may consider that insofar as it gives you meaning to other circumstances. On the other hand, you may consider the absence of motive in weighing whether or not the defendant is guilty of attempted murder. If, after consideration of all the evidence, you are convinced beyond a reasonable doubt that the state has proved all the elements of the crime of attempted murder, then your verdict must be guilty. If, however, after a consideration of all the evidence, you find the state has failed to prove each and every element of the crime of attempted murder beyond a reasonable doubt, your verdict must be not guilty. I'm going to now address, ladies and gentlemen, the lesser included offense to attempted murder, which is aggravated assault. The law requires that the court instruct the jury with respect to a possible lesser included offense, even though the offense is not contained in the indictment. Just because the court is instructing you concerning a lesser included offense does not mean that the court has any opinion one way or the other about whether the defendant committed this or any offense. You should consider this offense along with those for which the defendant is indicted. However, you are not to render a verdict on the lesser included offense or answer the questions on the verdict sheet regarding the lesser included offense unless you find the state has failed to meet its burden with regard to the offenses listed in the indictment, namely attempted murder. Regarding counts 1 and 2 of the indictment, you may consider as a lesser included offense the offense of aggravated assault. As I said, however, do not render a verdict on these offenses or answer the questions on the verdict sheet unless you find the state has failed to meet its burden with regard to the offenses in counts 1 and 2, namely attempted murder. The relevant section of our statute dealing with aggravated assault reads as follows. A person is guilty of aggravated assault if he attempts to cause serious bodily injury to another or causes such injury purposely or knowingly under circumstances manifesting extreme indifference to the value of human life, recklessly causes such injury. Under this statute, the defendant can be found guilty if he either caused serious bodily injury to another or attempted to cause serious bodily injury to another. To find a defendant guilty of aggravated assault for causing serious bodily injury to another, the state must prove beyond a reasonable doubt each of the following elements. Number 1, that the defendant caused serious bodily injury to another. And number 2, that the defendant acted purposely or knowingly or acted recklessly under circumstances manifesting extreme indifference to the value of human life. The first element that the state must prove beyond a reasonable doubt is that the defendant caused serious bodily injury to another. Serious bodily injury means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. The second element that the state must prove beyond a reasonable doubt is that the defendant acted purposely or knowingly or acted recklessly under circumstances manifesting extreme indifference to the value of human life. A person acts purposely with respect to the result of his conduct if it is his conscious object to cause such a result. A person acts purposely if he acts with design, with a specific intent, with a particular object or purpose, or if he means to do what he does, e.g., I did it on purpose. A person acts knowingly with respect to the result of his conduct if he is aware that it is practically certain that his conduct will cause such a result. A person acts recklessly with respect to the result of his conduct if he consciously disregards a substantial and unjustifiable risk that the result will occur from his conduct. The risk must be of such a nature and degree that, considering the nature and purpose of the actor's conduct and the circumstances known to the actor, its disregard involves a gross deviation from the standard of conduct that a reasonable person would observe in the actor's situation. One is said to act recklessly if one acts with recklessness, with scorn for the consequences, heedlessly, foolhardily. The phrase, under circumstances manifesting extreme indifference to the value of human life, does not focus on the state of mind of the actor, but rather on the circumstances under which you find that he acted. If, in light of all the evidence, you find that the conduct of the defendant resulted in a probability as opposed to a mere possibility of serious bodily injury, and you may find that he acted under circumstances manifesting extreme indifference to the value of human life. In determining whether the defendant acted purposely or knowingly, or acted recklessly under circumstances manifesting extreme indifference to the value of human life, You may consider the nature of the acts themselves and the severity of the resulting injuries. If you find that the state has proved each element beyond a reasonable doubt, then you must find the defendant guilty. All jurors do not have to agree unanimously concerning which form of serious bodily injury aggravated assault is present, so long as all believe that it was one form of serious bodily injury or the other. However, for a defendant to be guilty of serious bodily injury aggravated assault, all jurors must agree that the defendant either knowingly or purposely or recklessly, under circumstances manifesting extreme indifference to the value of human life, caused serious bodily injury to Lauren Kanarek as to count 1 and Rob Goodwin as to count 2. If you find that the state has failed to prove any element beyond a reasonable doubt, then you must find the defendant not guilty of the charge of aggravated assault in that he caused serious bodily injury to another. As I previously instructed you, the defendant can be found guilty if he either caused serious bodily injury to another or attempted to cause serious bodily injury to another. To find the defendant guilty of attempting to cause serious bodily injury to another, the state must prove beyond a reasonable doubt that the defendant purposely attempted to cause serious bodily injury to another. If you find beyond a reasonable doubt that the defendant attempted to cause serious bodily injury, it does not matter whether the injury actually resulted. The law provides that a person is guilty of attempt if, acting purposely, he did anything that under the circumstances as a reasonable person would believe them to be was an act constituting a substantial step in a course of conduct planned to culminate in his commission of the crime. The step taken must be one that is strongly corroborative of the defendant's criminal purpose. The accused must be shown to have a firmness of criminal purpose in light of the steps he had already taken. These preparatory steps must be substantial and not just very remote preparatory acts. Again, serious bodily injury means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. And again, a person acts purposely with respect to the result of his conduct if it is his conscious object to cause such a result. A person acts purposely if he acts with design, with a specific intent, with a particular object or purpose, or if he means to do what he does, e.g., I did it on purpose. If you find that the state has proved beyond a reasonable doubt that the defendant attempted to cause serious bodily injury to another, then you must find the defendant guilty. If you find that the state has failed to prove beyond a reasonable doubt that the defendant attempted to cause serious bodily injury to another, then you must find the defendant not guilty. I'm going to move on now, to the third and fourth counts of the indictment that charge the defendant, Michael Barisone, with the crime of possession of a firearm with a purpose to use it unlawfully against the person or property of another. Count 3 of the indictment charges in relevant part the grand jurors of the state of New Jersey for the county of Morris upon their oaths present Michael Barisone on or about August 7, 2019 in the township of Washington in the county of Morris knowingly and unlawfully did possess a certain weapon, to wit, a Ruger 9mm handgun, with a purpose to use it unlawfully against the person or property of Lauren Kanarek, contrary to the provisions of NJS 2C:39-4A1, and against the peace of this state, the government, and dignity of the same. Count 4 of the indictment charges the same crime, but as it pertains and uses the same language. The only difference is count 4 pertains to the use of the firearm unlawfully against the person or property of Robert Goodwin, contrary to the same provisions as listed in count 3. The relevant statute on which this count of the indictment is based reads in pertinent part as follows. Any person who has in his possession any firearm with a purpose to use it unlawfully against the person or property of another is guilty of a crime. In order for you to find a defendant guilty of this charge, the state has the burden of proving beyond a reasonable doubt each of the following four elements. Number one, Exhibit S-177 in evidence is a firearm. Excuse me. Number two, the defendant possessed the firearm. Number three, the defendant possessed the firearm with the purpose to use it against a person or property of another. And number four, the defendant's purpose was to use the firearm unlawfully. The first element the state must prove beyond a reasonable doubt is that Exhibit S-177 is a firearm. A firearm means any handgun, rifle, shotgun, machine gun, automatic or semi-automatic rifle, or any gun, device, or instrument in the nature of a weapon from which may be fired or ejected any solid projectable ball, slug, pellet, missile, or bullet, or any gas, vapor, or other noxious thing by means of a cartridge or shell, or by the action of an explosive or the igniting of flammable or explosive substances. It shall also include, without limitation, any firearm which is in the nature of an air gun, spring gun, or pistol, or other weapon of a similar nature in which the propelling force is a spring, elastic band, carbon dioxide, compressed or other gas or vapor, air or compressed air, or is ignited by compressed air, and ejecting a bullet or missile smaller than 3/8 of an inch in diameter with sufficient force to injure a person. The second element that the state must prove beyond a reasonable doubt is that the defendant possessed the firearm. To possess an item under the law, one must have a knowing, intentional control of that item accompanied by knowledge of its character. So, a person who possesses an item, such as a firearm, must know or be aware that he possesses it, and he must know what it is that he possesses or controls. That is, a firearm. Possession cannot merely be a passing control, fleeting, or uncertain in its nature. In other words, to possess an item, one must knowingly procure or receive an item or be aware of his control thereof for a sufficient period of time to have been able to relinquish his control if he chose to do so. The state must prove beyond a reasonable doubt that a possessor acted knowingly in possessing the item. A person acts knowingly with respect to the nature of his conduct or the attendant circumstances if he is aware that his conduct is of that nature or that such circumstances exist, or he is aware of the high probability of their existence. A person acts knowingly as to a result of his conduct if he is aware that it is practically certain that his conduct will cause such a result. Knowing with knowledge or equivalent terms have the same meaning. Knowledge is a condition of the mind. It cannot be seen. It can only be determined by inferences from conduct, words, or acts. Therefore, it is not necessary for the state to produce witnesses to testify that a particular defendant, stated, for example, that he acted with knowledge where he had control over a particular thing. It is within your power to find that proof of knowledge has been furnished beyond a reasonable doubt by inference, which may arise, from the nature of the acts and the surrounding circumstances. A person may possess a firearm even though it is not physically on his person at the time of the arrest, if he had, in fact, at some point prior to his arrest, had control over it. Possession means a conscious, knowing possession, either actual or constructive. A person is in actual possession of an item when he first knows what it is, that is, he has knowledge of its character, and second, knowingly has it on his person at a given time. The law recognizes that possession may be constructive instead of actual. A person with knowledge of its character knowingly has direct physical control over an item at a given time is in actual possession of it. Constructive possession means possession in which the possessor does not physically have the item on his or her person, but is aware that the item is present and is able to and has the intention to exercise control over it. So, someone who has knowledge of the character of an item and knowingly has both the power and the intention at a given time to exercise control over it, either directly or through another person or persons, is then in constructive possession of that item. The third element that the state must prove beyond a reasonable doubt is that the defendant's purpose in possessing the firearm was to use it against the person or property of another. Purpose is a condition of the mind which cannot be seen and can only be determined by inferences from words, conduct, or acts. In determining the defendant's purpose in possessing the firearm, you may consider that a person acts purposely with respect to the nature of his conduct or a result of his conduct if it is his conscious object to engage in conduct of that nature or to cause such a result. That is, a person acts purposely if he means to act in a certain way or to cause a certain result. A person acts purposely with respect to attendant circumstances if the person is aware of the existence of such circumstances or believes or hopes that they exist. The defendant's purpose or conscious object to use the firearm against another person or the property of another may be found to exist at any time he is in possession of the object and need not have been the defendant's original intent in possessing the object. The fourth element that the state must prove beyond a reasonable doubt is that the defendant had a purpose to use the firearm in a manner that was prohibited by law. I have already defined purpose for you. This element requires that you find that the state has proven beyond a reasonable doubt that the defendant possessed a firearm with the conscious, objective, design, or specific intent to use it against the person or property of another in an unlawful manner as charged in the indictment, and not for some other purpose. In this case, the state contends that the defendant's unlawful purpose in possessing the firearm was to use it to shoot Lauren Kanarek and or shoot at Robert Goodwin. You must not rely upon your own notions of the unlawfulness of some other undescribed purpose of the defendant. Rather, you must consider whether the state has proven the specific unlawful purpose charged. The unlawful purpose alleged by the state may be inferred from all that was said or done and from all of the surrounding circumstances of this case. However, the state need not prove that the defendant accomplished his unlawful purpose in using the firearm. If you find that the state has failed to prove any of the elements of this crime beyond a reasonable doubt, your verdict must be not guilty. On the other hand, if you are satisfied that the state has proven each and every element of the crime charged beyond a reasonable doubt, your verdict must be guilty. All right, ladies and gentlemen, I'm going to move on to the charge regarding insanity. Apart from his general denial of guilt, the defendant maintains that he is not guilty of the crimes charged in the indictment or the lesser included offense by reason of insanity. If you find that the state has failed to prove beyond a reasonable doubt any essential element of the offense or the defendant's participation in the offense, you must find the defendant not guilty, and you need not consider the evidence as to the defendant's insanity. If you find that the state has proved beyond a reasonable doubt each essential element of the offenses, either those charged in the indictment or the lesser included offense, and the defendant's participation in the offense, you must then consider evidence as to the defendant's insanity. All persons are assumed capable of committing crimes. Insane persons, however, are not capable of committing crimes. It is therefore necessary for me to instruct you with respect to the law of insanity, so far as it relates to the responsibility of a person for the commission of a crime. First of all, the law entertains no prejudice against the defense of insanity. On the contrary, if the defense of insanity is sufficiently established, the law allows the defendant the benefit of it by an acquittal of all criminal responsibility. To consider this defense, it is necessary that you understand the law's concept of criminal responsibility. Our society and our law recognize that some people may be bad and some people may be sick. A hostile act, that is, an illegal act, may be one. Let me start over. A hostile act, that is, an illegal act, may in one case spring from wickedness, and in another from some infirmity or sickness of the mind, which the individual did not design. It is society's moral judgment, recognized by our law, that a forbidden act should not be punished criminally unless done with a knowledge of wrongdoing. The law, however, from considerations of public policy, the welfare of society, and the safety of human life, proceeds with care, requiring that the proof of such a defense of insanity be established consistent with a standard recognized by law. Under our law, all persons are assumed to be sane and therefore responsible for their conduct until the contrary is established. Insanity is an affirmative defense, and the burden of proving it by a preponderance of the evidence is on the defendant who asserts the defense. If there is no preponderance of evidence of insanity, the defense of insanity fails, and the defendant stands in the position of a sane individual responsible on all the evidence in this case for his acts, whatever you may find them to have been. The law adopts a standard of its own as a test of criminal responsibility, a standard not always in harmony with the views of psychiatrists. If at the time of committing the act, the defendant was laboring under such a defective reason from disease of the mind as not to know the nature and quality of the act he was doing, or if the defendant did know it, that he did not know what he was doing was wrong, the defendant was then legally insane and therefore not criminally responsible for his conduct. As you can see, the law regards insanity as a disease of the mind. It may be temporary or permanent in its nature, but the condition must be a mental disease. An accused may have the most absurd and irrational notions on some subject. He may be unsound in mind and be a fit subject for confinement and treatment in a mental hospital. But if at the time of the offenses, the defendant had the mental capacity to distinguish right from wrong and to understand the nature and quality of the act done by him, he is subject to the criminal law. These principles must necessarily be the governing principles in the administration of the criminal law, or the most terrible crimes would not be punishable, for such crimes are almost always committed under the influence of an impulse which overcomes the restraint which usually prevents the commission of a crime. Therefore, to establish insanity as a defense to the criminal charge in this case, the defendant must prove by a preponderance of the evidence that defendant was laboring under such a defective reason from disease of the mind as to not know the nature and quality of the act, or if defendant did know it, that he did not know that what he was doing was wrong. The term preponderance of the evidence means the greater weight of credible evidence in this case. It does not necessarily mean the evidence of the greater number of witnesses, but means that evidence which carries the greater convincing power to your minds. Keep in mind, however, that although the burden rests upon the defendant to establish the defense of insanity by a preponderance of the credible evidence, the burden of proving the defendant guilty of the offenses charged here beyond a reasonable doubt is always on the state, and that burden never shifts. The question is not whether the defendant, when he engaged in the deed, in fact actually thought or considered whether the act was right or wrong, but whether the defendant had sufficient mind and understanding to have enabled him to comprehend that it was wrong if the defendant had used his faculties for that purpose. To determine whether the defendant has established by the preponderance of the credible evidence that at the time of the commission of the alleged offense, defendant was laboring under such a defect of reason from disease of the mind as not to know the nature and quality of the act he was doing, or if defendant did know it, that he did not know what he was doing was wrong, you should consider all of the relevant and material evidence having a bearing on his mental condition, including his conduct at the time of the alleged act, his conduct since, any mental history, any lay and medical testimony which you have heard from witnesses who have testified for the defense and for the state, and such other evidence by the testimony of witnesses or exhibits in this case that may have a bearing upon and assist you in your determination of the issue of his mental condition. There is a conflict of medical testimony, and you will have to determine where the truth lies. As is true with all issues of fact, the issue is for you to resolve after a careful consideration, comparison, and evaluation of all the evidence which is material to or relevant on the issue of defendant's sanity. The assumed sanity of the defendant is not overcome until you determine that the defendant has sustained his burden of proving by a preponderance of the evidence that at the time of the offense alleged, defendant was insane under the legal definition of insanity and therefore is absolved of criminal responsibility for conduct for which he would otherwise be criminally responsible under the law. The jury is the sole judge of the weight to be given to lay and psychiatric testimony. Generally speaking, no distinction is made between expert testimony and evidence of another character. The same tests that are applied in evaluating lay testimony may be used in judging the weight and sufficiency of expert testimony. You are the sole judges of the credibility of the medical witnesses as well as all other witnesses, and the weight to be accorded to the testimony of each. You saw and you heard them. You had the opportunity to observe their attitude and demeanor on the witness stand. You had the opportunity to hear their means of obtaining knowledge of the facts and to notice their power of discernment, their candor or evasion, if any, and the general and special professional and expert qualifications and background. These factors, any possible bias in favor of one side for whom each testified, and any other matters which serve to illuminate the statements of each may all be considered by you in determining the credibility of the expert testimony and the weight to be accorded it or any part of it. The medical experts have testified that statements were made to them by the defendant, which statements were part of the history they secured from the defendant. As I have previously instructed you, these statements should not be considered as substantive evidence against the defendant relating to his guilt or innocence of the alleged offense, but only as evidence tending to support the ultimate expert conclusion of the psychiatrist or psychologist receiving the history on the test of insanity. The witness, in effect, is not saying that such history is true. The witness is merely testifying that the statements comprising the history were made to him. You may, in fact, determine from the evidence in this case that the facts set forth in such history are true, not true, or true in part only, and in light of such findings, you should decide what effect such determination has upon the weight to be given to the opinion of the expert. However, if a medical expert has testified that his opinion hinges upon the truth of the matter asserted by the defendant, at the time the defendant gave the history to the doctor, the probative value of the psychiatrist's opinion or the psychologist's opinion will depend upon whether from all the evidence in the case you find that those facts are true. The same is true for any other facts relied upon by the expert. If the doctor has decided that he accepts as true certain facts on which the doctor bases his opinion, your acceptance or rejection of the doctor's opinion will depend to some extent on your findings as to the truth of these facts. With regard to the verdicts here, you may return one of three verdicts. The first is not guilty, the second is guilty, and the third would be not guilty by reason of insanity. If you find that the state has failed to prove beyond a reasonable doubt all or any one of the essential elements of the offense, or the defendant's participation in the offense, you must find the defendant not guilty. If you find that the state has proved beyond a reasonable doubt all the essential elements of the offense and the defendant's participation therein, and if you also find that the defendant has not established a defense of insanity to a preponderance of the credible evidence, then you must find the defendant guilty of the offense. If you find that the state has proved all the elements of the crime and the defendant's participation therein beyond a reasonable doubt, and if you also find that the defendant has established the defense of insanity by a preponderance of the credible evidence, your verdict must be not guilty by reason of insanity, and you shall so report and declare your verdict. A verdict of not guilty by reason of insanity does not necessarily mean that the defendant will be freed or that the individual will be indefinitely committed to a mental institution. Under our law, if you find the defendant not guilty by reason of insanity, it will then be for the court to conduct a further hearing and, among other matters, determine whether or not the defendant's insanity continues to the present and whether the defendant poses a danger to the community or to himself. The resolution of those issues will ultimately determine what appropriate restrictions need to be placed on the defendant. Thus, procedures exist to adequately provide for the defendant and to protect the public in the event the defendant is found not guilty by reason of insanity. Again, with regard to the verdicts, you may return one of three verdicts: not guilty. Number 2 would be guilty. Number 3, not guilty by reason of insanity. I will now give you some information on the final part of these instructions on conducting your deliberations. There is nothing different in the way a jury is to consider the proof in a criminal case from that in which all reasonable persons treat any questions depending upon evidence presented to them. You are expected to use your own good common sense. Consider the evidence for only those purposes for which it has been admitted, and give it a reasonable and fair construction in the light of your knowledge of how people behave. It is the quality of the evidence, not simply the number of witnesses, that control. As I said before, any exhibit that has not been marked into evidence cannot be given to you in the jury room, even though it may have been marked for identification. Only those items marked in evidence can be given to you. Very shortly, you will go into the jury room to start your deliberations. I remind you that during deliberations, and in fact, any time that you are in the jury deliberation room, you must keep any cell phone, pager, anybody use pagers anymore? Or other communication device you may possess turned off. You are to apply the law as I have instructed you to the facts as you find them to be for the purpose of arriving at a fair and correct verdict. The verdict must represent the considered judgment of each juror and must be unanimous as to each charge. That means all of you must agree if the defendant is guilty, not guilty, or not guilty by reason of insanity on each charge. It is your duty as jurors to consult with one another and to deliberate with a view towards reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors, or for the mere purpose of returning a verdict. You are not partisans, you are judges, judges of the facts. You may return on each crime charged a verdict of either not guilty, guilty, or not guilty by reason of insanity. Your verdict, whatever it may be as to each crime charged, must be unanimous. Each of the 12 members of the deliberating jury must agree as to the verdict. To assist you in reporting a verdict, I have prepared a verdict sheet for you. You will have this with you in the jury room. You'll have the indictment. I will give you a copy of my charge, a full copy of it so you can review the charge regarding any aspects of the charge that I gave you. And you'll have a copy of the verdict sheet as well. The form is to be used to report your verdict, and I did supply a copy of that to the state. Can you pull that up for us as I review it with the jurors? All right, just scroll up a little bit, please. Right. The jury verdict form lists count 1 as attempted murder, and it lists not the entire charge in the indictment, but a portion of it to help guide your deliberations. And count 1A is the attempted murder as to Lauren Kanarek, and it lists the possible verdicts: not guilty, guilty, not guilty by reason of insanity. If you answer guilty or not guilty by reason of insanity on question 1A, please go on to question 2A. If you answer not guilty, then you may go on and consider the lesser included offense of aggravated assault as set forth in question 1B. And that pertains to whether or not the defendant attempted or did cause or attempted to cause serious bodily injury to Lauren Kanarek. And again, the possible verdicts, if you reach that lesser included offense, would be not guilty, guilty, or not guilty by reason of insanity. Count 2 is the attempted murder charge as to the attempt to cause the death of Rob Goodwin. With regard to count 2, possible verdicts as listed: not guilty, guilty, or not guilty by reason of insanity. As with count 1, if you answer guilty or not guilty by reason of insanity on question 2A, please then go to count 3. If you answer not guilty on the attempted murder charge, then you can consider the lesser included offense of aggravated assault. And that's listed in question 2B, and again, your verdict's not guilty, guilty, or not guilty by reason of insanity. Question 3 pertains to count 3, possession of a weapon for an unlawful purpose, as it pertains to a purpose to use it against the person or property of Lauren Kanarek. Again, your verdict's not guilty, guilty, or not guilty by reason of insanity. And then you consider finally count 4 of the indictment charging possession of a weapon for an unlawful purpose to use against the person or property of Robert Goodwin. And once again, those verdicts are not guilty, guilty, or not guilty by reason of insanity. The verdict form that will go into the jury room will have a line for the signature of the person appointed foreperson. And when you have reached the verdict, the unanimous verdict, please, the foreperson will sign the verdict form and advise the court officer standing outside that you have reached the verdict. Please do never advise anyone where you may stand with regard to your verdict. They should only hear that you have a verdict, and the foreperson will read that verdict in open court. If during deliberations you have a question or feel that you need further assistance or instructions from me, or wish to have certain testimony played back for you, please write your question or request on a sheet of paper and give it to the staff member who will be standing outside the jury room door. who in turn will give it to me. Court officer will be sworn to perform certain duties such as keeping the jury together in a private place for purposes of deliberations and ensuring that no one speaks with you except by order of the court. You are not to discuss with or ask the officer about trial matters or procedures. Please be aware that the officer is also instructed not to initiate communication with you or to enter the deliberation room without your consent, except to communicate on my behalf regarding administrative matters such as information about breaks or meals, or otherwise to ensure your comfort. If the officer must enter the deliberation room, the officer will knock first and complete the officer's responsibilities without delay. When the officer enters the room, please stop your deliberations and do not resume any deliberations until the officer has left and closed the door. Once I receive any question or request from the jury, I will go over it with the attorneys first, and I will try to answer it as quickly as possible, but please be patient in that regard. If you do not send out a question, or if you do send out a question, please do not disclose where you stand on deliberations. Never tell us, for example, that you stand 10-2 or 8-4 on a given charge. If you have reached a unanimous verdict on each charge, knock on the door, let the officer know that you have reached the verdict. Again, never tell the officer, and we'll bring you back into open court and we'll receive your verdict in open court. I have come to the end of my charge. As I said, I'll give you a written copy of my instructions along with the indictment and a copy of the verdict form to assist in your deliberations. Can I see counsel at the bench, please? Ladies and gentlemen, at this time we will select the alternate jurors. There will be 4 selected. My clerk's going to come over here. We have a box that the juror numbers only. Seat numbers have been placed in the box, so we will spin that box. And select the number.
Jury number 9.
All right, Mr. Wetter. Yes. All right, you're the first alternate juror.
One second.
Step in, they'll be sworn. Just stand right there while you're sworn.
Okay. Where's mine? I'm gonna check if she's in chambers. Just grab Miss Kupka. Miss Kupka.
Oh,
Let's grab her.
Found her, Judge.
Sorry.
Paper and pens are out there. Is right there.
She probably went to go get hair.
We have all the staff members that will watch over the jury room and the room where the alternate jurors will be housed. Please listen to the oath and respond accordingly. Raise your right hands, please.
Do you swear that you will do your best to keep every person sworn on this jury together in a private place, and that you will not allow any person to speak to them, nor to speak to them yourself except by the order of the court, and only to ask them if they have agreed upon a verdict until they have agreed?
I do.
I do.
All right, thank you all. All right, the staff members have been sworn. All right, members of the deliberating jury, you may now retire to the jury room to commence your deliberations. Very shortly, the computer and the evidence will be brought in to you to assist you, and you can review that during your deliberations. Thank you. And the alternate jurors selected can just remain in the courtroom for the time being. I'll have some further instructions for you.